topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Orlando. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. Our show today, we might just rename the whole show from Ask the Experts to K. Bender Rimbaum. They're a community association law firm. They're out of Pompano, but they also have offices in Tampa and Orlando. They actually cover the entire state of Florida. Our expert today is from their office. He's out of the Orlando office, and we have a new name for him now. He's now board certified, Alan Swartseed. Hey, good afternoon, Alan.
Thank you, Steve. Yeah, it's been an exciting development over the last few weeks since the last show. Board certification is very important to me, and I'm glad the Florida Bar is recognizing, I guess, my expertise, my experience, and I can now finally match up and go toe to toe officially with 7 others within the firm that are also board certified in this area of law.
It's quite an honor, and you really have to put a lot of work into that.
Yeah, I was very glad to get my results because it means I don't have to do that work again. I just got to keep putting the work to, remaining within the industry and keeping up to date, which is part of what we do on a daily basis and part of what we're here to discuss today, I guess, Steve.
Yes, I tell you, one of the great things about K. Bender Rimbaum is they really believe in education, and the people like Alan and Robert K. They give their time for free to educate you. They have classes which we're going to be going over during the show, all the classes they have coming up. But Alan, everybody is wanting to know about. There's so many new laws that the governor has signed on.
Yeah, so are we doing a 2-hour show today and talking about nothing else, Steve? Because
right.
But yes,
I was
there's a
Alan that we our biggest show.
Yeah, Tuesday was major for Tampa, but there are 5 major bills that impact community associations, actually 6, because one of them impacts community association managers, not necessarily the association itself. But there are a couple major ones out there that really kind of changed the whole game, so to speak. We can get into detail if we've got questions about them that we'll answer today. But there have been a bunch of I would call it like a sea change as to a couple different topics. Some of it, my perspective is, in reality, it's not going to be enforceable for a while or for a lot of existing communities, but we can go into detail about each one if we get to it, but there are a lot of changes. My guess is within the next few weeks, hopefully, we will get approved by the DBPR to teach that class, a legal update, as a CE class so that managers can get credit for that. But if you've got a community that needs that class and needs to know what's going on, you're welcome to email me. If you got a management firm that needs these legal updates, you're also welcome to email me because I do teach these classes, again, like Steve mentioned, for free for individual management firms.
Alan K. Bender Rimbaum has got the greatest website. There is so much great information on there. Is there anything about any of the new laws on your website?
Yes, actually, if you go to Jeff Rembaum's Roundup, which is on our website, which is kbrlegal.com, under the resources tab, you go to Rembaum's Roundup, the first thing you're going to see is our legislative update. And that is a 39-page document that goes through the basics of everything that changed that impacts community associations and managers this year. So it is a huge document, and it'll take you a while just to read it. But that, I think, is probably your best resource, other than once we come out with an actual class explaining some of this stuff. Because, we're going through the basics, but for example, in a specific law, if I'm telling you I don't think this is applicable, that's not going to be included in that breakdown that we're providing to everyone. We'll provide it to everyone. It's just not part of Jeff's Roundup article. But I do recommend taking a look at that, because it's a great resource. And frankly, I keep it on my desktop on my computer, because it's something I'm referring to on probably a daily basis right now, if not multiple times a day, in case there's something that I want to make sure. I'm one of those nerds where you ask me a question, I know the answer, but I'm still going to look it up and make sure I got it right. So I use that as a resource pretty much, I'd say, multiple times a day over the last 3 weeks since Jeff put it out. So I think that's probably your best bet, is go on our website and check out the resources tab.
Well, like we do for all of our shows, we allow you to ask us questions, and you can text it to me at 954-336-3767, or you can send them to me like most people do at Stephen. It's STEVEN at AskTheExpertsRadioShow.com. We have got so many questions for you, Alan, and gosh, you always manage to do such a great job answering them. Let's get started. Does an earlier foreclosure on HOA property invalidate a cost-sharing agreement on the property?
I mean, if you're talking about a cost-sharing agreement that's recorded and runs with the land, probably not. And, a cost-sharing agreement is basically, hey, we're going to share and spread out the cost of doing some type of maintenance, repair, replacement of an asset. I don't care what asset it is. So what I'm saying is, if that was recorded in the county public records and it includes the legal description of the land that it pertains to, chances are a foreclosure is not going to wipe that out. It's just like the covenants of a condo or an HOA that survive that foreclosure. The short answer is it would depend on certain factors, but most likely that cost sharing agreement survives the foreclosure. Whether that's a mortgage foreclosure or an association lien foreclosure doesn't really matter.
I got to do this, Alan, because it is so special. We are getting so many texts, people putting on the chat line, people congratulating you. And I stopped the show for that.
I genuinely
it is a big deal.
It is. I've been to a couple for the last few days, and same thing. People have stopped me and called me over, and it's a really nice feeling to be recognized, not only by the bar, but by my peers. I was at an Inns of Court meeting, which is basically a bunch of judges and attorneys meeting up together and talking about the law last night, and was stopped by several judges, several other attorneys. So I don't want to take the whole show up talking about that, but I agree that it's a big deal. I genuinely appreciate it. And hopefully people also have questions and are not just here to congratulate. But I do appreciate it from Steve and from our listeners.
Okay, so because of all these new laws, can a person's 18-year-old HOA completely create new CCR, and how to start?
Okay, so it sounds like you're basically saying you've got to, and I apologize if I'm misunderstanding the question, but if you've got an 18-year-old community and what you're trying to do is basically completely redo all of your documents, yes, that's an option, but it's going to require a lot of work by an attorney, and it's going to require a vote of your members. If all you're trying to do is change the covenants that govern your community, then it doesn't require a brand new corporate entity and getting approval from the government of the state of Florida and having a new developer. Really, all you have to do is have someone look through your documents, prepare an amended and restated declaration that contains the covenants you want in there, and then the members get to vote on it. I mean, that's a process that we work on a fairly regular basis, and it usually will entail an initial stage of us going through everything, letting you know statutorily what is okay and what's not, what complies with Florida law, what changes you really should versus need to make. And then the board gets to decide, what do we want to put in here? Now, keep in mind also, that can be a time-consuming and expensive process. It might be easier to just adopt a couple amendments if you're sitting here saying, we need to completely redo everything, but really all you want to change is 4 concepts. That's going to be a significantly less costly project for the association. And if you're only making a couple changes, I don't really recommend starting from scratch and creating a new declaration, or even, starting from scratch with an amended and restated declaration, unless you got a bunch of previous amendments that you can consolidate everything together so that it's easier to review everything in one document. But if you're talking about, well, we created a community 18 years ago and we want to make a couple changes, just do a single, simple amendment process. That's still going to require a member vote, but it's going to cost you $10,000 to $15,000 less than completely redoing your documents. Usually if we're talking about just 1 or 2 changes, you're looking at maybe 3 to 5 hours. It's not a major undertaking. If you're talking about a complete redo, we're talking about thousands and thousands. So I understand, I think, what the question was, but I think you need to look at, what do we really want to change? What do we really not like about what our documents require? If you don't like what the board's doing, get on the board and make some changes. That's a different story.
Okay. Let's go to Brian from Citrus Highlands, HOA, wondering if there's a statute that prevents redaction of personal information on official records.
So the only statute that would allow...
He said, we require ARB violation report forms to be signed by a member in good standing in order for action to be taken.
Yeah, I mean, the problem with trying to redact that information is that it's now an incomplete record. There's nothing in the statute that says that document, that's not personal information, that's someone's name. If the address that they're listing is a mailing address that's already listed in the association records, then it's already in the association records and it's something that statutorily you're required to produce. What you might be able to redact are phone numbers or email addresses that are not being used for purposes of association notices. But a name and an address, not something that you'd really be able to redact. My recommendation there would be to have an amendment that says, and I'm presuming that this is something that's already in your declaration, and that's why you're requiring that name and contact information from the person that's reporting the violation. If it's not required, stop requiring it, and then you don't have that issue. But if it is required under your governing documents, I would suggest that you reach out to me and we can work on an amendment. And for people that are not current clients of the firm, same deal. Have your attorney, or if you're not comfortable reaching out to your attorney, that's not one you should be using, and feel free to contact me directly. But that's something that I work on, these amendments pretty much every day. Like I said in response to the last question, that's something that I think it would be appropriate to take out of the documents. And I think you'd be able to sell that amendment to your members who need to vote on the amendment by saying, we're trying to make it easier for you to report this and not have us be legally obligated to out you for having done so. So Brian, if you want to discuss that, feel free to shoot me an email. My email address for everyone that is attending is as@kbrlegal.com. That's usually going to be the easiest way to find me, unless you want to just follow me on LinkedIn and see what nerdy things I come up with on a daily basis to share with everyone.
Alan, I don't know if you remember. Well, you should remember. When we did our show on Tuesday, we actually got somebody who wrote us from Boynton wanting to know
Okay.
about the pulling up all the grass at the golf course. They did a follow-up and they said they have removed the sign out front and they're putting in a new sign that's going to be $500,000. Does that sound right to you?
I mean, does the new sign say it's going to cost them $500,000 to put the sod in? I mean, that's the problem. I don't know what that sign represents. What's the $500,000? And for those that weren't with the sign,
they're constructing a new sign out front. It's always been made of stone, but I don't know what they're doing with it now.
Apparently, if it's going to cost them $500,000, it's made of gold. I really don't know. It depends what they're doing. I mean, I've worked with communities that have built really beautiful signage that's surrounded by foliage that includes solar lighting and things of that nature. I don't know what would cost $500,000. Maybe it's a large sign. And now that you're mentioning it, I think it probably is my parents' community because I was there a few weeks ago and the sign is gone. So it wouldn't surprise me if it was. But that if that's what we're talking about, it's a gigantic sign in the middle of a lake that will probably be lit beautifully because that community does a fantastic job with everything that they're doing. And if that's the case, candidly, I don't have enough experience looking into what that kind of signage and having to, take everything over on a John boat or whatever they're going to use, what that would cost. But yeah, I think it's probably feasible that would cost a good amount of money because just moving the materials to where the signage is located is probably going to cost a couple grand. So, it's not ideal. I understand that. But if it's that community, they are really beautifying the entire place. And you know what? Again, like I said on Tuesday, for those that weren't with us, this is a project to beautify the entire community. They were pulling up sod, and the question was, why the heck would they do that when no one has any money and can barely afford to pay their current assessments? And my answer was they're beautifying the community to make it competitive with others that are in the area. Now, you mentioned this is in Boynton Beach. We're in the Orlando show. I manage the firm's Orlando office, but like you also mentioned, these things apply statewide. We're not talking about local ordinances. So any answer I give in Boynton is probably going to be the same thing I would give to a country club community in Orlando. So this applies, and I wouldn't look at this as wasted time for any of you listening. Understand that if your board of directors is beautifying your community, all they're doing is increasing your property values. So yeah, you may pay more in assessments until that project's done, but chances are your property value is higher if you ever decide to sell. And it is very funny to me that this happens, I think, to be the community my parents live in. But I'm not going to divulge which one that is because I don't want them to get inundated with people yelling at my parents because they happen to hear something I said.
Oh, my son, the lawyer.
It's more of a New York accent, but otherwise that's pretty accurate.
Okay. Let's go to Sherry in Orlando. What do you like when it comes to voting, paper or electronic?
Well, I mean, you have a legal obligation to provide both options unless people have opted into electronic voting. But I like giving the option because, one, there are so many people in Kissimmee, in Orlando, in other areas, the state, especially down in South Florida, that don't live in their units, and those units are rented out, and the tenants are not providing notices or anything. But if you're getting those notices electronically, which you pretty much have to do almost all the time for electronic voting, then you're going to know when these votes are coming up. The association is going to get a lot more people voting if your vendor is good enough to get them to opt in. And by the way, that should be your vendor's responsibility, not the board's responsibility, to get people to opt in. Because frankly, the vendor makes more money the more people that are actually using the system. So my suggestion is offer both, but find a vendor that's going to do a good job and also do the work to get people to sign up so that you can meet a quorum requirement if you want to do an amendment. You can meet quorum if you want to have an election. It's the whole purpose of this is to make it easier for people to vote. So I think that offering electronic voting is something that most communities, in my opinion, should be doing. If you've got a 15-unit condo, yeah, that's probably not necessary. But, if you're looking at more of a 150 unit or, a 50 lot HOA, it's probably appropriate to try and get 10 people that otherwise wouldn't vote to vote for you. And now you can meet your quorum requirements and actually get things passed. So I don't know if that answers the question. I like both for different purposes. And when I say different purposes, there are elderly people and tech-averse people in Florida that will not vote if the only option is electronic. They'll never opt in. I say the only option is electronic. They have to opt in before you can require them to vote that way. But just understand, I like both, but I think that offering electronic voting as an option is going to benefit almost every community that tries to do it.
Should an HOA get workers' comp insurance to protect board members and other volunteers doing maintenance work for the HOA?
If you're going to allow them to do physical labor, maybe, but keep in mind, they're not employees. So you probably need a separate policy that pertains to people doing work on your property. I know that it's going to cost more, but do you want to buy that insurance or just pay a vendor to do it and require them to have that insurance and pay for it? It's 6 in one, half a dozen in the other. But frankly, you're far more protected if it's a vendor that's doing that work that is properly insured versus the association just having people go onto the property and start working for you. At a minimum, I would suggest that they sign a liability waiver that's prepared by your attorney before anyone starts volunteering to do physical labor for the association. I was literally just talking to Joe Stanoff, my associate, before we hopped on to this radio show about how his community it's located in Longwood, Florida. And it essentially is where they have kind of a voluntary association. They collect very little up front, but they use that money to beautify 1 or 2 things a year or every other year. And they have a couple people that the neighbors adjacent to the signage water the plants that are adjacent to the signage using their own wells. And, you've got the wonderful little old ladies that do all the landscaping and all the keeping the plants nice and cozy. That's great, but they're putting themselves, the association is being put at great risk. If one of those people falls while they're trying to do the work, they're going to claim that, the association, the board asked them to do the work and they got injured doing it. I mean, and workers' comp probably wouldn't cover that because they're volunteers. So I don't know that workers' comp is appropriate unless you've got employees. There might be an insurance policy that would cover that. It's probably your general liability policy that covers damages on the property. But in reality, my recommendation is if you're considering spending the money for that insurance, spend the money for a vendor to do the work instead.
Okay, you know what? We've got a board full of calls, but let's go and share your schedule with everybody.
Sure. So tomorrow at 10 a.m., I will be teaching the last condominium board member certification class before the new requirements, kick in on July 1st. So if you need to get a board certification class in for condo in particular, I'd strongly suggest you jump on that one. It's free. It's on Zoom. You can register right on our website for any of these classes. July 11th at noon, the importance of updating your governing documents. July 12th at 10 a.m., the Community Association Legislative Update will be taught. That's the one that we were talking about earlier. It's not going to be for credit, but it will be extremely valuable. July 24th at 11 a.m., another legislative update, this one for condos. And then July 25th at 11:30, I will be teaching a fair housing class talking about, is this an assistance animal, a service animal, or a pet? And how do we deal with disability-related requests? in a condo versus in an HOA? What is the Americans with Disabilities Act versus Fair Housing Act, and issues like that? So super exciting, but let's be realistic. I don't know of any community association that hasn't dealt with a fraudulent ESA request in the last few years. That's why this class is valuable. So that's what we've got coming up this month. I know there are additional classes that are being scheduled that will be on Zoom. I talked about one just today, but it hasn't been formally scheduled yet, so I can't divulge those details yet. But check out our calendar on kbrlegal.com. We'll be adding those as they pop up. And there is one within the next 2.5 weeks that I know is also going to be taught that isn't on there. So that's what we've got coming up. I know July is usually a slow month because realistically, no one wants to take a class on this stuff while they're on their summer vacation. But I also understand how important it is for people to learn about these things if they're new to the board. So that's what we've got. And Steve, thanks for the opportunity to explain, what we've got coming up in the next month or so.
Okay, before we go to break, I'm going to get one more question in. With the new changes, 720, it says that trusts will be allowed. Will this apply to condos 718?
I don't know what kind of trust you're referring to that's going to be allowed. 720 for
Probably
anyone that doesn't realize. I'm sorry? Oh, trucks.
Probably a work truck.
I thought you said trusts as in trusts and estates. So let's clarify that.
Oh.
Yes. This only applies to 720, which is HOAs. It's not the law for condos. And the change in the law was that essentially if someone's got a pickup truck or a work truck, meaning they've got a ladder on it, they've got, commercial lettering on it, logos on it, you can't do anything about that in an HOA anymore as of July 1st, unless it also complies or applies where there is a statutory definition of a commercial motor vehicle. It's basically one that uses special fuel, isn't a government truck, and is of a certain size. Now, if you're in an HOA and your governing documents don't contain what we call Kaufman language, which is basically adopting the amendments to the statutes it's the HOA Act as amended from time to time. That's the language you want to look for, or more realistically, have your attorney look for. My opinion, and I know a couple other attorneys within our firm of 20, there's at least 10 that I've talked to that feel this way as well, is that this statute is an unconstitutional restraint on an existing contract, which is the declaration. The problem with making that argument is that it's going to take an attorney that's willing to do it and an association that's willing to do it to take that case up to the Florida Supreme Court so that they can strike down this law. And what that means is a couple $100,000 in attorney's fees. So unless you think you've got someone that's going to support you through that, and when I say someone, that could be groups like CAI that, I hate to say it, will probably support the owners instead of the association. A couple other groups that might be out there, attorneys that might support this type of litigation to knock this law out. It's really a risk analysis that the board has to perform to decide whether we wait and see if an owner brings this law up and then we fight it, or we just decide across the board, we're going to treat the statute as though it's applicable, even though the attorney's opinion might be that it shouldn't be. So that's a long way of saying it applies unless you are willing to make the argument that it doesn't. But it does not apply. The truck rules and the commercial vehicle rules do not apply to condos that have changed. The rules that have changed this year in the Florida legislature do not apply to condos. It's HOA only. Won't apply to co-ops either, by the way.
Okay, we're going to go to break. Tell people how they can reach your office, Alan.
Sure. So my personal email for work is as@kbrlegal.com. If you've got any questions, feel free to reach out to me anytime. If you have any questions for the firm as a whole, or you want to talk on the phone, the number is 954-928-0680. That will reach any of our offices, whether that's Pompano, Tampa, Palm Beach Gardens, or my office in Orlando.
Okay, we're going to go to break. When we come back, we have more with Kay Bender Rimbaum. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We want to thank everybody for all their messages, their questions we're getting. Again, you can text us at 954-336-3767 if you've got a question for Alan. I want to make sure that I know people are going to the chat line. We have so many things on our plate here to do that it's hard to get to all the chat people. So don't feel offended if we don't get your question on chat. We are getting about 50 questions a month on this show. The show has become so popular. We're going to go to our questions again. This is from Jerry in Orlando. Okay. We have a small HOA and find it a problem to get a board of 4 people. How can we get more people involved in the board?
Well, one thing you can do is reduce your board to 3, depending on what your bylaws say. They may say you need to have between 3 and 7 or 3 and 9. You know, I hate to kick anyone off, but reduce it to 3 so that you can make decisions. You're not deadlocked. If you want to get more people on, just explain to them that they can be part of the decision-making process for the association, meaning that they get to control what happens in their own community. If you can't find anyone that cares enough, I hate to be blunt, but that's not a problem that is uncommon in Florida. I mean, I routinely have communities having a tougher time, especially with some of the changes to the law that make it even more difficult to be a board member. I frequently find that the bigger problem is not figuring out who to allow onto the board. It's finding people willing to serve in the first place. So if you're comfortable with 4 and you're routinely on the same page and able to make decisions and you're not worried about that potential deadlock, just keep the 4 and keep doing what you're doing. But if you find that there is a regular disagreement, then maybe you need to have an election. Now, the problem if the next election that comes up, if the plan is to figure out which 3 will stay on at that point because no one's willing to step down, the problem's going to be that if you can't find people to serve, you probably can't find people to vote either, and you won't have the election. So everyone rolls over to the next election, or at least the next term. So, I wish there was a way that you could incentivize people, but realistically, my free classes and things like this are the best incentive I know of. You can't really pay people. I guess in an HOA, technically you could look at your documents and see if they allow it, but I'd be surprised if that loophole isn't closed immediately by the legislature next year anyway, because they're closing everything else and making HOAs just like condos, even though that makes no sense. It wouldn't surprise me if they start closing every loophole that we can find to try and benefit people and convince them to actually serve on a board.
Chris in Orlando, we received an insurance settlement and never had a board vote. How can we see what happened to that money?
Well, the board might have voted during a mediation. The board might have voted outside of a board meeting. You can request to inspect the official records. I don't know if Chris is on the board or not. If not, and Chris is trying to figure out, what happened here, request to inspect the official records of the association, and hopefully there will be either meeting minutes or a written resolution of what happened here. Alternatively, if there was actual litigation, you might look on the court's docketing report online for your county, and that might actually show a settlement agreement that can show what money was given to whom, who signed the settlement agreement, et cetera. And, hopefully that person that signed was authorized to do so. But other than, getting answers from the board or records inspection or looking at the docket, there's really not a lot that I might be able to tell you to do, because it is entirely feasible that your board didn't do it the right way. Hopefully they did, and hopefully the records will show that. But if not, I don't really know what recourse you'd have to try and challenge the validity of that settlement. I think from the question, you just want to know what happened, and that's totally understandable. But I think you're kind of limited to those three options here.
You did such a great job with the question we had on Tuesday, and I'm getting all these people who are asking the same question. They all want to know, Alan, what do you like about the new laws?
I like the education requirement that board members are required to actually be educated about what their obligations are and how to do things the right way. Up until July of this year, the requirement was that you either sign a piece of paper saying, I've read the documents and I'll do my best, or you actually take a class like the one I'm teaching tomorrow. The people that have signed a piece of paper generally have no idea what the hell they're doing. They've never run a corporation before, which, by the way, is what you're doing if you are on the board of directors of an HOA or a condo or a co-op. They tend to have less knowledge and don't even know the right questions to ask their CAM or their attorney. Whereas the people that have taken these classes, even a boring one that I didn't teach, tend to do better and understand a little bit more of what their obligations are, and they're better equipped to comply with those requirements. Now the law is going to say you not only have to take an actual class, but you're going to be required to take a continuing education, so that when legal changes are made, like the statutes that I said it would take 2 hours to go through this year, you're going to have to actually know what's going on in the legislature. You're going to have to know what you should be doing with respect to collection of assessments, covenant enforcement, things like that. You're just less likely to make a mistake if you actually know what your obligations are. I'm trying to think of anything else that I like. Most of it was stuff I don't like. I know you'll be shocked. I like the additional educational requirements for managers, because I think that the initial licensure requirement, it requires like a 1-day class, I think, and then taking a test, which is certainly not easy. And there are plenty of people that are not capable of doing it. And I don't want to downplay the importance of being a licensed manager, but I think that the educational requirements specific to HOAs and specific to record keeping, I think those are two of the areas that the legislature got it right, where there are plenty of condo managers that know nothing other than how to manage condo. And we're in Central Florida. Yeah, there are condos, but there are far more HOAs in this area than there are, for example, in South Florida. It kind of flips, where in South Florida, it's almost all condo, and you've got a couple HOAs here and there. Here in Central Florida, it's the reverse. It was kind of a rude awakening for me to get up here and say, well, I know condo law really well, but I guess I got to learn HOA better now. That was back in 2018. Don't worry about my qualifications now, but that was a big change for me. There's not a lot else, frankly, that I like that was changed. I like that they've outlined a little bit better what the fiduciary responsibility is. That's the obligation that all of the directors owe to the members. so that everyone understands, it's been in case law for a while as to you can rely on advice of counsel and things like that. Now it's being put directly in the statute so that even people that don't know about the case law, haven't taken a board certification class, or at least haven't taken a good one, will understand what their legal obligation is and what the limitations of that obligation are. I can't think of anything else offhand that I like. And that's out of 39 pages, there's about a page and a half that I'm saying I like. I'll put it that way. So you asked what I like.
Oh, my
There's
God.
a lot more that I don't. I'll put it that way.
Let's go to Millie in Orlando. She has a condo. And by the way, when you text us, please let us know if you're a condo or an HOA. It does help. Millie says, I sent a registered letter to the new property management requesting financials, and they keep turning me down. What can I do? They are not up on the website.
I don't know what you mean by they're turning you down. If the response is they're not ready yet, then that might be an appropriate response. If the response is we're not going to provide that to you, then you probably have a minor cause of action, is what I call it. There are legal penalties for refusing to provide records to an owner. Now, keep in mind, I'm presuming that you own your property and that you are sending it to the property manager that actually manages, and that the property manager is the proper recipient of that request. If all that's true and you've been sending requests, and they technically have 10 business days to provide those records to you for inspection. If they're not on the website, they're not accessible anywhere else, and they're basically saying, go do what you got to do, I'm not providing you anything, then that's probably an inappropriate response, and you might have a cause of action, which would basically be $500 in damages, which is $50 a day beginning on business day 11 after a proper request was made, up to that $500 cap, plus your attorney's fees and costs. The first thing you're going to want to do is probably going to be to have an attorney take a look at your situation and figure out what your rights are. I don't really handle that side of things. I'm generally, and our firm as a whole is generally on the association side. But if you want to reach out to me directly, I'll be happy to put you in touch with some people locally that might be able to help you out with this particular situation.
Okay. Mary in Altamont Springs, I believe we had someone who asked a question like this on Tuesday. My condo association used reserve funds to settle a litigation problem. Can they do that?
Generally, reserves that are true reserves, not just some money that's been put aside as a line item of whatever we need, but true reserves would require a vote of the members to vote in favor of using those funds for a different purpose. The only thing I'll point out is that I have had clients ask, can we use it, if we've got a construction defect settlement and we need to settle that lawsuit? Yeah, maybe if the lawsuit pertains to the asset that the reserve was intended to cover, then maybe you can justify that without a member vote. But generally speaking, you would need a vote of the members in order to use the funds for any other purpose other than their initially intended purpose that they were put into a reserve account for.
What should a condo association use for collateral? If the association wants to take a loan, use the common element repairs, replacement.
No. Never, ever use your common areas as collateral. What you want to use is the right to collect or even to levy assessments against the individual units. But you never want the association to provide those common areas as collateral. Think about it. Do you want a bank owning your pool? Do you want a bank owning your elevators? No. You want your members to have the unfettered right, other than what the association decides should be restricted, to use those common areas. So I'm sorry, Steve, to interrupt, but as soon as I heard the beginning of the question, I knew what the answer was going to be. Do not use your common areas. Do not use your common elements as collateral. That applies to condos as well as HOAs. Think about it. Okay, let's say you're in an HOA and you've got common areas instead. Do you really want them foreclosing your playground, your pool, your parking lot? No, you do not. You want to work with a bank that understands this area of law, or at least understands how community associations work well enough to allow you to say that the collateral is going to be a special assessment or something of that nature. What I also don't recommend is, frankly, using the same bank where you bank that can just access your funds immediately and just say, well, you didn't pay the mortgage. I'm taking everything you've got. Now your operating account is drained. So I'm not saying don't do it. I'm saying there is risk in using the same bank. I am saying absolutely don't use your common elements, common areas as collateral for a loan or for anything else.
Okay. Our docs call for a board of 3 to 7, like you were saying just a minute ago. Current board is 1 member. Should this be reported to the state office?
I wouldn't report it, but what I would suggest is, for the person that cared enough to ask this question, if you're not the one, volunteer for the board and make it 2. That 1 member currently gets the right to appoint another person. But if this persists for a while and that 1 person is refusing to allow anyone else on the board, that's basically a dictatorship. And, I've dealt with communities that only had 1 director, and the guy that was running it, he did a great job. He was doing his best. He was asking for legal guidance whenever it was appropriate, but he couldn't find anyone else to serve. In that instance, it's a different story. If this is someone who's refusing to appoint anyone, refusing to have elections, then rather than report it to the state, you might consider what's called a receivership so that the association can be run properly. And that receivership will result in attorney's fees and costs paid by all the members until you can get enough people on the board that the board takes over from the receiver and the receivership is terminated. This is not a quick or easy process. It's costly, but from my perspective, it's probably the right way to do it. If you want to report it to the state, that's your prerogative. I just don't think the state would have jurisdiction to do anything other than say you need to hold an election, which isn't going to get you anywhere, because if this person is refusing to hold elections, that's what you'd be going after, not the fact that there's only 1 director.
Well, we got a lot of questions in today, and I got to tell you, we appreciate your questions. The next show is going to be the first Thursday each month at 5 o'clock, and then the last Tuesday and Thursday of each month at 5 o'clock. So I want to thank you. Alan, tell people again how they can reach you in your office.
Sure. So the easiest way to reach me is going to be via email. It's as@kbrlegal.com. You can alternatively reach us at the office, any of our 4 offices, via phone, 954-928-0680. And again, if you're interested in daily tips that I try to post, usually pertaining to being an attorney involved in the community association industry, or being a mediator or doing mediation, follow me on LinkedIn and check me out. That's about all I got. Thank you, Steve.
Alan, we are so lucky to have you. That's my suck up. Have a wonderful 4th of July.
Thanks, everybody.
And we'll see you next month. Thanks, Alan.
All right.
That's Alan Swartzide, K. Bender Rimbaum. Thank everybody for all your questions. We tried to get in as many as we could. People love this kind of format. We'll be back again with you next Thursday at 5 o'clock with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.